Wills and Trusts webinar series, which is being put on in collaboration with Legal Network Wales and Legal Network London, which are free referral and support networks for law firms run by Hugh James. And I'm asked to pass on the following information about them. The network has assisted hundreds of law firms to retain their clients by offering expert legal advice in areas they do not practice in or are unable to due to the existence of a conflict. In return, the network can offer a fee share and a commitment that Hugh James will not poach, cross-sell, or market their services to the referred clients. If you'd like to know more about the network, please could you indicate this on the feedback questionnaire, which I understand will appear on your screen when you leave the webinar. And we'd be very grateful if you could please complete it and return it, as it's very helpful to us when it comes to developing our seminars in the future as well. The webinar is being recorded, and I understand that a link to this will be made available at a later date. There are 3 speakers today, and the webinar is expected to last for about an hour, including a short question and answer session at the end. So if you do have any questions as we go along, please feel free to type them into the chat box and we will do our best to answer them at the end. Or equally, of course, please do raise any questions during the Q&A itself, which we're delighted to say will be chaired by our guest speaker, Matthew Evans, who is a partner and head of private wealth at Hugh James. Matthew will also be speaking on funeral and burial rights, including who has the right to decide what in relation to those matters, and possible legal remedies when a dispute arises. And Charlie Newington-Bridges, a colleague of mine at St. John's, will then be discussing estrangement and adult child claims under the 1975 Act, following the decision in Re H last May. But before we hear from Matthew and Charlie, I'm going to discuss the burden of proof in will forgery claims. So I'm just going to share, I hope, my slides with you. Thank you for bearing with me. So I'm going to look at, firstly, where the burden of proof has been thought to lie in will forgery claims. And then I will go through 3 cases from last year, 2 of which depart from what are thought to be in the accepted position. And finally, I'll consider where that leaves us now when it comes to the burden of proof in will forgery claims. Haider and Said is often cited as the authority for the proposition that the burden of proof lies on the person asserting that a will is a forgery. However, as indeed was later noted in Sampson and Cunningham, the judgment simply proceeded on that basis after it was accepted by counsel for the party asserting that the will was a forgery, that it had to prove the same. Mr. Justice Barling even stated that there being general agreement as to the principles I should follow, I need dwell no further on the law. And so the point was not subjected to either argument or judicial scrutiny. It is also notable that, at least as far as I could see, the only authority in relation to the burden of proof in will forgery claims, which is cited in the latest edition of Theobald, is Sampson and Cunningham. So it seemed fair to say that while it was generally accepted that the burden lay on the person alleging that the will was a forgery, the issue had not been settled. Nonetheless, so far as the burden of proof in will forgery cases goes, last year kicked off with a restatement of what had been the generally accepted position in Ball and Sisson. But this was again just a bold statement that the burden was on the claimant, as the party seeking to prove that the will was a forgery in that case. Again, there had not been any real engagement with the issue. What perhaps was unusual in that case, however, was how hopeless the forgery ultimately was. Firstly, the alleged will was said by the defendants to have been executed at their house, with considerable detail being provided about the precise circumstances, including where they were seated. But there was CCTV fitted at the deceased's house, demonstrating that she didn't leave her home on the day that they said that this was done. There were also telephone records demonstrating the deceased had been at her home at 2:37 p.m. on the day that the will was said to have been executed, which, on the defendant's own case, gave them just over half an hour for the deceased to have been picked up, driven to the defendant's house, sat down at their table, read the alleged will and the letter of wishes, and this compared with the 2013 will, the will executed, and the deceased driven back to her home in time to make a phone call at 2:37 p.m. Quite a feat, perhaps, particularly for an elderly woman with mobility problems. There were also some fairly appalling sounding evidence from the attesting witnesses, including one of the witnesses explaining discrepancies between his witness statement and his oral evidence as being just words. Needless to say, such a casual attitude to the truth did not find favour with the judge.
Sorry to interrupt, Danny. I can't see your slides changing. I'm not sure if your PowerPoint is full screen.
Thank you. They are on full screen. I will try again. Thank you so much for letting me know. Is that any better?
No, I can't see it still. Would you mind stop sharing and re-sharing just to try it again?
Yeah, of course. Thank you. Okay, I'm not sure that I'm actually going to be able to share or at least change my slides, because it says my screen sharing is paused. So I think I will just have to continue without them, but perhaps we can send them out at a later date. And I'll do my best to read what's on them so that it's reasonably clear.
Okay, I will send out the notes at the end.
Thank you. The final paragraph of that judgment, which is at paragraph 139, in case you want to have a look at it at a later date. In that paragraph, the judge expresses considerable sympathy for the first defendant in that case, the first defendant having been the individual who forged the will, which does seem particularly odd in the context of the evidence that the judge had just heard. And certainly the same generosity was not extended to those involved in the forgery in Face and Cunningham. And next came the decision in Re Brunt. That is a decision from July last year. And this acclaim arises in very unusual circumstances. The deceased had died in 2007, and his estate had been administered by his mother, the first defendant, on the basis that he had died intestate. However, more than 10 years after the deceased's death, his uncle sought to propound a will from 1999, which had been discovered in 2018. Further, that will had not been signed by the deceased himself, but Mr. Howard Day, who was in 1999 the deceased attorney. So it was suggested it was signed at the deceased's direction. And not only that, but Mr. Day had in 2003 been sent to prison, having been convicted of fraud as a result of his role in a fraud perpetrated by Fayers Legal Services Limited. And by the time of the trial, he had actually died. So despite what sounds like a pretty unpromising start, the will was held not to be a forgery and was admitted to probate. And that was also despite the judge in those circumstances holding that, contrary to the generally accepted position, the evidential burden of proof was on the claimant to demonstrate that the will was not a forgery. And that was so even though the defendants accepted that the burden was on them to prove that it was. And that's set out at paragraph 73 of that judgment. And indeed, at paragraph 74, the judge went on to quote from Re H that the more serious the allegation, the less likely the event occurred, and hence the stronger should be the evidence before the court concludes that the allegation is established on the balance of probability. Although Re H, of course, goes to the standard rather than the burden of proof, it seems that the idea of the standard of proof not being fixed, but existing on a spectrum, is being applied also to the burden of proof. The matters alleged by the claimant are inherently unlikely, so he must establish sufficient evidence to discharge the evidential burden. Such an approach with a shifting burden of proof is of course not unusual in probate cases. For example, as set out in the 2010 case of Key and Key, the burden of proof in relation to testamentary capacity shifts. While the burden starts with the propounder of a will to establish capacity, where the will is duly executed and appears rational on its face, then the court will presume capacity. In such a case, the evidential burden then shifts to the objector to raise real doubt about capacity. If real doubt is raised, the evidential burden shifts back to the propounder to establish capacity nonetheless. So Master Teverson's proposition in Re Brent that the person seeking to propound the will faces an evidential burden of proof that the will is not a forgery is not without parallels. What might also be of note from this case is how unpersuasive the expert evidence in forgery cases can be. Here, when held against all of the other evidence, the judge was not persuaded by the expert evidence, on which both experts were actually agreed, that the signatures were added at a later point in time, and that it would be quite a coincidence for Mr. Day to have written the signature on the first will in 1999 in an unusual style relative to his writing at that time, and in a manner which is not found until later dated signatures. But the judge noted that quite a coincidence implied that it was unlikely but not impossible, and this was enough for him to prefer the other evidence in this case in order to propound the will which was otherwise alleged to be a forgery. However, this decision was not the end of the road for this case. Although the decision on appeal is, I think, as yet unreported, I understand that a retrial has been ordered following a successful appeal by the defendants. It will certainly be interesting to see how the burden of proof is dealt with at the retrial, particularly following Face and Cunningham, which I will now consider. So Face and Cunningham is a decision from October 2020, and the will was held to be a forgery in this case, it having been discovered under a sleeping bag in the deceased's house, but smuggled out by the claimant, allegedly. It was also described as being drafted in utterly incredible terms, and the evidence of the attesting witnesses was held to be entirely ludicrous. However, in contrast to the compassionate tone struck in Ball, His Honour Judge Hodge QC was absolutely damning of those involved in the forgery in Face and Cunningham. The claim seeking to propound the will was dismissed as being totally without merit. He didn't even need to hear closing submissions from the defendant before reaching this conclusion. The claimant was ordered to pay the defendant's costs on an indemnity basis, and quite frankly, those matters were the least of her worries, as it was ordered that a copy of the transcript of the trial be provided to the CPS. It is also another forgery case in which the expert evidence simply did not assist, this time because it was inconclusive. But more importantly, for our purposes, it was again held that the burden of proof was on the propounder of the will, rather than those alleging that it was a forgery. His Honour Judge Hodge QC also went further than Master Teverson had in Brunt, by stating that this was a general proposition and not something confined to the particular facts of the case. The justification he gives for this conclusion as to the burden of proof is that a claim that a will has been forged goes directly to its formal validity rather than its substantive validity. And it is of course the case that it is for the propounder of the will to prove due execution. In reaching this conclusion, he also stated that Haider and Said is no authority for the proposition that the burden of proof rests on a party alleging that a will is forged, as previously discussed, the proposition not having been challenged in that case. However, it is not clear how this fits with the fact that, as in this case, forged wills often appear on their face to have been duly executed and so formally valid. Is a mere allegation of forgery sufficient to shift the burden to the propounder despite apparent due execution? His Honour Judge Hodge QC's judgment would seem to suggest that the answer to this question is yes. So where does that leave us now? Unfortunately, with a variety of conflicting High Court decisions, although it is notable that, at least of those considered this afternoon, where the point was engaged with rather than taken as read, the conclusion reached was that the burden was on the propounder of the will, which would seem to suggest that this is the more persuasive view. However, as Master Teverson's finding as to the burden of proof was helpful to the appellants in re Brunt, it is perhaps unlikely that the appeal court will have addressed the point in any great detail, but it's nonetheless hoped that that decision will be reported, as it's likely to be an interesting one. In addition, the retrial, particularly if reference is made to Face and Cunningham, might provide an opportunity to provide clarification, albeit still just at High Court level. So I think basically the answer is watch this space. And while I'm perhaps reluctant to ask the following question, having just discussed the point in some detail, does the burden of proof actually matter? Although the burden of proof is rarely determinative in civil cases, probate cases are perhaps one area in which it is of greater importance, not least of all because the person who would otherwise be the star witness has died. This difficulty can then be compounded by it not being possible to trace attesting witnesses, or they too having died, and these gaps not readily being filled by expert evidence in forgery cases, as is underlined by its virtual irrelevance to the conclusions reached in re Brunt and Face and Cunningham. Therefore, clarification on where the burden of proof lies would be of assistance, and certainly at least until that clarification is forthcoming, where there is an allegation of forgery, the propounder of the will would likely be ill-advised to rely upon it being for the person alleging the forgery to prove it. So thank you. I'm now going to pass over to Matthew for his talk on funeral and burial disputes.
Thanks, Annie. Right, bear with me a second. I'm also going to attempt to share my screen. Hopefully this will work. Okay, thank you. No doubt somebody will let me know if it's not showing up as clicking through, but hopefully it will. Right, so this talk is called Burial, Ashes and Funeral Disputes. This is a matter that I've been personally wrestling with in one of my own caseload fairly recently. So I know it's an issue that can become incredibly emotive and difficult for executors to deal with. I think that's particularly so for professional executors who can find themselves thrust into the middle of a family dispute with really little insight into the issue other than what's possibly written in a will many years previously. In our experience, this can potentially derail what's an otherwise fairly straightforward estate administration. It can also give rise to an exponential increase in costs. Those costs can be borne by the estate or sometimes swallowed by the professional executor's firm, depending on how well they've drafted their retainer. So I think it is quite pertinent to a lot of practitioners. So today I'm going to rattle through the general principles which govern the area of law, the issue of who has the duty to dispose of a body, and then look specifically at some disputes in that context. I'll then discuss the extent to which a testator's wishes are relevant in resolving these disputes, before looking at the finer practicalities of transportation, funerals and headstones. And then finally, I'll review the relevant practice and procedure and look at what the future might hold and possible proposals for reform. This is a truncated version of a longer talk given previously. So in the interest of brevity, for most of the cases, I'll only really deal in brief with the principles of law established. But if you do want more details about the facts of the case, some of which are very interesting, then we can, of course, provide you with a full list of all the authorities and citations. So let's have a look firstly at the general principles. The first and most fundamental point to know is that, to use the words of Mr. Justice Kay in the 1882 case of Williams and Williams, there can be no property in the dead body of a human being. Judge Hale, as she was then, reiterated this in Buchanan and Milton in 1999, but she also reminded us that there is a duty of common law to arrange for the proper disposal of a body, which usually falls upon the PRs of the estate. Crown and Fox is an historical but interesting case in which a jailer refused to deliver up the body of a prisoner in his custody to the executors unless they agreed to settle debts which he said were owed to him by the deceased. In that case, the court held that a corpse can't be the subject of property transactions or offences. It can't be bought or sold, it can't be stolen or criminally damaged, or as in this case here, it can't be seized by creditors as security for debts. For the same reason, a corpse can't form a person's estate, and nor can it pass under a person's will or under the intestacy provisions. Finally, though, there is a main overriding point that the court has an inherent jurisdiction to direct the method of disposal of a body, and that happened in the case of Oldham and Metropolitan Borough Council and Macon and others, which is probably better known as the Ian Brady case, which I'll come back onto later when we discuss it in a bit more detail. So let's firstly look at the duty of disposal and disputes that can, and in my experience do, arise in relation to them. So as I've said, the primary duty for disposal of the body falls on the PRs of the estate. However, where there's a genuine dispute regarding the PR's entitlement, the duty will then normally fall upon the person in possession of the body at the time. In the case I put there, University Hospital Lewisham NHS Trust, the NHS Trust applied to court for directions as there was an ongoing will dispute and therefore uncertainty about who the PRs would ultimately be, which in turn led to a dispute about whether the body should be buried or cremated. In that case, the court ultimately held that it's the duty of a whole householder under whose roof a person has died to make arrangements for the dignified and decent burial of the deceased. And in this case, the term householder was broadened to include the hospital, and the trust was therefore able to dispose of the body as per the court's direction. Similarly, in Lang and John Poyser solicitors, and the key point that the court made was that the defendant executors were in lawful possession of the body and therefore entitled to dispose of it. That said, subject to this, it does remain the PRs who have the ultimate right and duty of disposal. They have the right to possession of the corpse and may determine the mode and place of burial, even where family members object. And that right also extends to ashes and remains, and that's set out in Lieburn and Derndorfer, which I've cited there on the slide and which I'll discuss in a bit more detail shortly. It should be said that the courts have proven reluctant to interfere with executors' decisions as to burial, unless those decisions are capricious, unreasonable, or made dishonesty. Where no PRs are appointed, the person with the greatest right to take granted representation can take possession of the corpse. Where the deceased died leaving a valid will, that's of course set out in Rule 20 of the non-contentious probate rules, and in the case of an intestacy, it's governed by Rule 22. That can give rise to problems of its own though. In Holtham and Arnold from 1985, for example, the deceased separated wife was ultimately entitled to possession of the corpse over and above his cohabitee when he died, as she was the person best entitled to the granted letters of administration. Similarly, in Smith and Tamworth City Council, the New South Wales Supreme Court held that the deceased's adoptive parents, rather than his biological parents, had the right to erect the headstone. In the absence of anyone willing or able to do so, the duty to dispose of the body falls on the local authority under the Public Health Act 1984. Conflicts can also arise, of course, where two or more people who are equally entitled disagree as to the manner or place of disposal. Generally, the courts adopt a practical approach. As the judge noted in Dodd and Jones, it can be difficult to weigh the competing claims and arrive at what one would truly call a legal judgment. Generally speaking, though, the court takes into account the following factors. Firstly, the reasonableness of the proposed arrangements. Secondly, the length of time which has elapsed. Thirdly, the wishes of those entitled. And fourthly, the practical need for the disposal of the body without undue delay. The application of those factors was illustrated in Fessy and Whitmore. This concerned a dispute between divorced parents over where to scatter their child's ashes. Judge Boggis in that case considered that the parents were akin to trustees, and that as such he was obliged to make a decision which did justice and fairness to both sides. And he ultimately concluded that the remains should be disposed of in accordance with the mother's proposals. The case of Lieburn and Derndorfer I mentioned previously, this also illustrates the sorts of factors the court would take into account. In this case, there were three executors who were in dispute about how the body should be disposed of. The son was one of them. He wanted the ashes disinterred so they could be split between the three of them. The judge ultimately refused to grant that order, and the reasons he gave were as follows. Firstly, a significant length of time had elapsed. By the time they got to trial, the ashes had been interned for 4 years. Secondly, it wasn't appropriate to divide the ashes contrary to the deceased's wishes. Thirdly, the majority of the executors had chosen to have the ashes interred, and the claimant was effectively in the minority. And fourthly, the judge wasn't satisfied that the choice of cemetery was inappropriate. So there's obviously scope for disagreement when a PR decides to dispose of a body. One way to challenge the PR's decision is to apply to pass them over their priority to take a grant pursuant to section 116, which we've probably all done in different contexts previously, and I'll discuss that in a bit more detail shortly. In Buchanan and Milton, which I've previously mentioned, the natural mother of the deceased was an Australian Aborigine who had given up her son, Dane, for adoption at 4 days old. He was subsequently brought over to the UK in 1979 when he was 6. When he passed away, there was a dispute between his adopted parents and his biological parents back in Australia. The birth mother applied under section 116 to appoint herself as the PR, which would thereby allow her to dictate the burial arrangements. Mrs. Justice Hale felt that the special circumstances cited in section 116 could in theory include all relevant circumstances of the case and not just those relating to the estate itself. But ultimately she felt that these were overridden by the need of the adopted family and of Dane's daughter to lay him to rest in a way that was appropriate to them. The biological mother's application under section 116 was therefore refused. This story was fairly widely reported in the press, both in the UK and in Australia. And again, I don't really have time to go into the facts now, but it's worth a read because it's really interesting from a factual perspective. In Burroughs and Her Majesty's Coroner for Preston, the court had to decide whether to pass over the deceased mother in favour of his uncle who had brought him up. And in the circumstances, the court felt it appropriate to do so, and that allowed the uncle to then deal with the funeral arrangements. In Abuna and Arroyo, the judge doubted that human rights could apply post-death, which was something that the judge in Burroughs had suggested. He did, however, acknowledge that express wishes from the deceased would and should be given consideration. And I'll consider the deceased wishes and the impact they can have on cases a bit later. So in addition to PRs, householders, local authorities, hospitals and mortuaries, others who have a right to dispose of a body include coroners, and in fact that right overrides all others. There's also various legislation dealing with organ, tissue and sperm donation, and I've set them out there, that also need to be borne in mind. As I've said already, often the identity of a PR may only be known following the outcome of a will dispute, for example, and as we all know, these disputes can be lengthy. The courts have made it clear that unless there's some proper reason why the disposal of the body should be postponed, it's not acceptable to wait until the dispute is resolved before disposing of the body. Of course, otherwise the PRs might in any event disagree amongst themselves about how the body should be disposed of. In either of those circumstances, absent leaving the arrangements to somebody in possession or to local authority, the only proper alternative for PRs is to seek direction from the court. And the court can generally approach this matter in one of three ways. Firstly, the court has an inherent jurisdiction to direct the method of disposal, and that brings us back to the Ian Brady case from 2017. You'll probably recall that in that case, his solicitor, a chap called Robin Makin, had been entrusted with dealing with the disposal of the ashes. He refused, however, to tell anyone what he was intending to do with them. There was a real fear that he may scatter them on the moors, which obviously would have been hugely inappropriate in the circumstances. The solicitor, Mr. Makin, offered to tell Sir Geoffrey Boss privately what he intended to do with them, but Boss said that wasn't good enough, and mindful of the overriding public interest, he simply appointed another person in place of the solicitor to deal with the disposal of the ashes. So that's a prime example of the court using its inherent jurisdiction to deal with a matter like this. In Hartsham and Gardner, this is another painful case with the competing parties being the parents of the deceased in a dispute about where the body should be buried. Ultimately, the judge felt that the appropriate order was to release the body to the father for burial. She outlined various case-specific factors that influenced her decision, but she also ultimately noted that the disposal of the body with proper respect and decency and without further delay was the most important consideration. As I've mentioned previously, the court also has a power under section 116, as we all know, to appoint an alternative PR, who will then of course be entitled to deal with the proper disposal of the body. The case of Anstey and Mundell from 2018, I just set out there what we probably already know, which is what section 116 says. The case of Anstey and Mundell is a good indication of how this works in practice. This was a dispute about whether the deceased should be cremated in the UK or buried in Jamaica, as he had expressed that he wanted in his will. The court ultimately reached a view that the body should be buried in Jamaica, or at least that's what they felt the deceased would have wanted. But rather than make an express judgment or order to that effect, the court instead utilised section 116 to appoint the daughter who was most likely to give effect to that as PR. So got you to the same place, but in a slightly more roundabout way, utilising a slightly different jurisdiction. And there's that case there. Finally, good old CPR 64, the friend to every professional executor. Of course, under CPR 64, the court has jurisdiction to determine any question arising in the administration of an estate of a deceased person, whether or not there is a grant. And that's your kind of catch-all provision for professional executors if they find themselves in a slightly sticky situation. We, as a firm, utilised this a couple of years ago in a case called Adams and another, and O'Connell and another, and we were able to obtain a direction from the court as to how our professional executive client should dispose of the body. So it works very well for us, and it seems a good way forward. Turning to testamentary wishes, we all know that whilst the person can express how they want their body to be disposed of, and they can authorise the cost of the same, those wishes aren't necessarily binding, and that goes back again to Williams and Williams from 1882. They can, however, as we've seen, have persuasive influence on the courts when dealing with burial disputes. Likewise, however, as in the Ian Brady case, the court can choose to ignore them altogether where it feels it's not in the public interests. As such, I think it's important that both will writers and testators consider those wishes carefully. That's particularly so, I think, when it comes to perhaps more unusual wishes, which I'm sure we've all come across in practice from time to time. I won't go into them in detail now, but I've set out there some of the legislation to bear in mind when thinking about that sort of thing. There's also some helpful government guidance here, which also has some useful guidance on pet burials if anyone needs that at some point. A quick aside, and I won't go into the facts of this case because unfortunately the time doesn't permit it, but this is a case, ReJS, where the court made a prospective order during the child's lifetime dealing with her post-mortem wishes. Briefly, she wanted her body to be cryogenically frozen so she could potentially be brought back to life when technology allowed it. And obviously she was a minor, she was capacious, so we couldn't utilise a statutory will, so the court made a prospective order to enshrine her wishes. Worth a read that case from a sort of legal, factual and scientific perspective. I think you're probably unlikely to come across an order like that, but it's worth bearing in mind that it is at least theoretically possible. Briefly, as we've seen, the extent to which human rights laws could apply is questionable. On the one hand, in Burroughs, the judge seemed to suggest they would. On the other hand, in Abuna, the judge was sceptical. I think it's generally accepted, though, that they probably don't apply post-mortem. So turning to funerals and headstones, what about disputes over transportation? Well, the substantive issue of whether or not the body should be transported outside the jurisdiction is ultimately for those tasked with making arrangements for its disposal. An obvious issue, though, is that once the body is removed from the court's jurisdiction, it may become impossible for future orders to be enforced. So where there's a substantial dispute, it may be necessary for PRs or whoever it may be to seek an injunction prohibiting removal of the body until the dispute is resolved, and that's precisely what happened in the case of Anstey and Mundell that I mentioned previously, where there was an intention to take the body to Jamaica. Turning to the funeral itself, the main principle is that the ceremonies are to be decided by the person entitled to make arrangements for disposal, subject of course to lawfulness, as I mentioned. But as we've seen in the Ian Brady case, the court can intervene even against the objections of the executor. The court's only likely to exercise this power in exceptional circumstances, though. As for funeral expenses, as we know, for solvent estates, provided they're reasonable in relation to the size of the estate, then these are payable out of the estate in priority to any other debts or liabilities. Where the estate's insolvent, only expenses deemed absolutely necessary are payable out of the estate. And if the PRs exceed these limits, they may risk personal liability for the excess. So again, one to bear in mind for professional PRs. In terms of headstones, there's a lot of detail there, but I think in the interest of brevity, all I'll say is that ultimately, in absent court intervention, the decision of the headstone, what to choose and what it should say, are down to the PRs. So, practical steps. Right, taking it back to the start, obviously, for will writers, the first practical step is to discuss funeral wishes in detail with the testator and make sure the testator understands that such wishes aren't binding but do carry weight potentially. I would say the testator should be encouraged to communicate those wishes and that those wishes should be detailed. Simply saying, for example, you want to be buried could lead to dispute further down the line, so I think it's important to be specific. In cases of dispute, we've discussed these briefly, so I won't go into them in detail, but the first is to seek to invoke the court's inherent jurisdiction. That's generally by application by way of a Part A claim form with supporting witness statement. You've also got the option of section 116, which we probably all know how to do, but it's, as you know, an application either to the High Court or to the Probate Registry with accompanying affidavit or possibly witness statement now. Or finally, as we've mentioned, good old CPR 64. So apply to the court for directions. Again, Part 8 claim form with supporting witness evidence. This last one is most likely to be the most appropriate application if there are disputes about headstones or something similar, given the broad nature of powers that the court has under CPR 64. I'd say executors should be wary of applying for directions at the first hint of a dispute due to the costs involved, but in the face of a serious dispute, it can be useful, and in my experience, it's a good way of, in the nicest possible way, knocking beneficiaries' heads together to try and get them to reach an accommodation as a family without incurring the cost of a full-blown court application. If there's urgency, of course, you may wish to consider an injunction. Put quite a lot of detail here, but in the interest of time, I think all I'll say for now is it's probably a topic of its own. So I simply flagged it here as a point of reference, but do bear in mind it is an option open to you if required. So that leaves me just briefly to touch upon the future and possible reform. In 2017, the Law Commission presented its 13th programme of law reform to Parliament, and within that it suggested a modern framework for disposing of the dead. You can find the programme online. There's a long quote from it that I'm not going to read now, but these are the links to the various proposals. Unfortunately, there's no clear indication of when this will be reviewed. The programme itself says that the expected start date is as and when resources allow. That was pre-COVID, and thereafter the expected duration is between 2 or 3 years. So given the current issues, reform is likely to be some way off yet, but it does appear to be on the cards. Okay, so I'm conscious that was a canter through quite a few different areas of law, but hopefully it gives you a feel and a starting point for the various issues that can arise and the practical steps that can be taken. As I say, if you want more detail of the cases, we can circulate a list of authorities and citations for you to have a look at. Otherwise, I shall pass over to Charlie for the final talk, and I'll stop sharing my screen. Thank you very much.
Matt, thank you very much indeed. Good afternoon, everyone. We thought you might need some light relief after funerals, dead bodies, headstones, and so on. So I bring you Re-H, which involved yet more death, psychological disorders, abject poverty, and estrangement between parent and child. You may or may not have seen this case when it was first reported. But it was a judgment of Mr. Justice Cohen in 2020. And as you can see from this slide, very simply put, the claimant was the 50-year-old daughter of the deceased father. There were two defendants. Firstly, the mother and the principal defendant, and secondly, the brother of the claimant, who was the personal representative of the deceased. The mother was the sole beneficiary of the deceased estate. She was about 80 years old. She was profoundly deaf. She was living in a care home, and she had a cancer diagnosis, so was also profoundly unwell in other ways. There were some fairly extraordinary procedural issues with the case. Firstly, the mother was debarred from effectively defending the proceedings, mainly because she'd breached so many orders prior to trial. Apparently, she hadn't filed an acknowledgement of service or any evidence, despite not only being given multiple opportunities to do so, but also having been ordered to do so. So effectively, there was no real defence to the claim, save for a 6-page letter from the mother to the court and a 2-page letter from a care worker in the mother's care home. But that was it. And as the judge observed during the course of the judgment, what that amounted to was opposition to the claim. But it really wasn't in any way, shape or form an effective defence to the claim. Another significant detail was the mother, for fairly obvious reasons, given the time of COVID and her diagnoses, was watching the trial from the care home. She couldn't hear any of it, so there was an interpretation service provided, I understand, from one of the care workers. But aside from that, she had no involvement whatsoever. So the background, claimant's background, she lived at home until her 30s. She had been supported at university by her parents, having gone there in her 30s. She had a breakdown in her early 30s. And while she said she saw her parents every 2 to 3 weeks between 2000 and 2010, it was clear on the facts that she'd had no involvement whatsoever with her parents for at least 10 years prior to her father's death. She had a long-term relationship from which had been produced 2 children, but the psychological issues that had manifested themselves in her 30s or early 30s continued, and she was diagnosed with a number of disorders, including OCD and a dissociative disorder as well. Financial dependence, well, scarcely. She'd been part funded through some studies by her father. He'd given her a monthly allowance and paid about £2,000 towards the course fees. And up until about 2007, she'd had access to a joint account from which she'd taken perhaps £100 a month. But again, that was only up until at most a decade prior to her father's death. Why the estrangement? Well, the judgment doesn't really help you to get to the bottom of that, to be perfectly frank. She'd had her first child in 2011, and apparently the father disapproved of that, although there was no reason given for that disapproval. As a result of that, the claimant had been removed from the joint account. Although it seemed to be the mother who bore the brunt of the estrangement, she had no involvement whatsoever with her daughter, at least from 2010. Apparently the claimant had spoken to her father occasionally, but certainly didn't visit. So it was clear that in the last decade prior to trial, there had been no involvement whatsoever between the 2 main parties, mother and daughter, save for at the deceased's funeral. What about the claimant's needs? Well, it was clear that she was impecunious. She had a rented property, and her principal claim was for £350,000, £400,000 to allow her to buy a property. She said that she needed at least 3 years worth of psychological therapy worth about £25,000. She said she needed a car and various white goods, although it wasn't apparent that a figure was attached to that part of the claim. And then there was a significant deficit between income and expenditure, and the claimant said that she needed £48,000 to fund that deficit. That was all in the context of an estate worth about £500,000, and so the claim would have consumed, if not all, then almost all of the estate had it succeeded in its entirety. Oh, and by the way, the main asset in the estate was the marital home, the deceased and his wife's marital home. His share, the deceased share, worth about £350,000. So, what was the legal context for the purposes of this claim? Well, you'll all be well aware with the case of Eilert and Mitson, but a few pointers or reminders insofar as they relate to adult children and estrangement. Lord Hughes, who gave the leading speech in that case, and with whom the other members of that court all agreed, said that need was a necessary but not a sufficient condition for a successful claim. You'll remember Re Coventry, one of the more important cases in this area, which specified or set out that there was no requirement for a moral claim, but of course that there was something more needed than a qualifying relationship. It wasn't enough to say, here I am, I'm the child of the deceased, I have some need, and therefore my claim should be successful. What is the additional something? Well, it wasn't necessary for there to be a moral claim, but a moral claim might or may, in the circumstances, provide that additional something. So, the quandary that was faced by the court in the circumstances: total lack of involvement from the mother, and you can imagine that she would have had some choice words for her daughter, given that she hadn't seen her for 10 years, and by choice the claimant had written her parents out of her life. And you get a sense of the dilemma, the sense of dilemma that the judge faced when he says, "The more that I contemplated the matter, the harder I have found it." You get a sense as you read through the judgment that at one point he might well have thought about satisfying all of the elements of the claim, perhaps surprisingly, in particular providing a fund for the claimant's house. But he recognised quite properly that this was a significant estrangement, and on top of that, there was no financial dependence whatsoever, and there hadn't been for certainly 10 years, possibly even longer. On top of that, of course, the size and nature of the net estate is critical in these types of claims, and it wasn't a large estate. So where did that get us? Well, it got us to an award of £138,000 or thereabouts. How did the judge get to that? Well, he said that the mother was the priority. He didn't seem to have any evidence on this point, but he recognised from the little that he did have that there were significant care home fees to be paid. He made the points about estrangement and the lack of responsibility, the lack of financial dependence. But he did note that the claimant's needs, in particular in relation to her health, were critical. And in fact, he found that they were more important than her housing needs. And he made this critical point, and I'd underline this, that the award needs to be sufficient to meet its object rather than run the risk of failing. So if the principal object of an award was to be directed towards the claimant's health, then it was important that the financial needs in relation to that were satisfied and satisfied properly. So what did he provide? Well, he provided those costs for the psychological therapy. He was prepared to fund the income shortfall for 3 years. Why 3 years? Well, that was the amount of time that it was said that the therapy would need to be successful. There would be a loss of universal benefit, so he funded that. The white goods and the car were provided, and there was a deposit for a new rental property to enlarge the space occupied by the claimant, her husband, and their 2 children. And there was a sum for a reasonable CFA markup, and I'll come back to that in just a moment. Where does that leave us, and what are the conclusions to be drawn from this case? Does it signal a slightly more accommodating approach from the courts in relation to adult-child claims, in particular in the context of estrangement? Well, in my view, I don't think it does. This was a peculiar case. Very often these types of cases feel singular on the facts, but there were some very particular circumstances, not only in the factual background, but also, as I say, in the procedural background. You'll remember that there was effectively no defence. And so I think it probably, or at least that fact, made it probably easier for the judge to find in favour of the claimant. Of course, the circumstances are always key and feed into the Section 3 criteria. But in this case, the very real health issues faced by the claimant were critical and one suspects were paramount in the judge's mind. You may well remember that it was generally thought after Eilert and Mitson that it was going to be rather more difficult for adult children to claim, and in particular to claim for very substantial sums. As I said at the outset when talking to this slide, I don't think that's changed. But I do think that had I been advising the defendant in this case, the mother, and I'd looked at this claim and thought about all those years of estrangement, the lack of financial dependence, even in the context of the health issues of the claimant, I think I would have been sceptical, in truth, about the claim, and therefore perhaps would have found this judgment surprising. So what do I take from that? Well, maybe I should think a little more carefully perhaps about how I advise on these types of cases. But I do think that a very rigorous assessment of the circumstances is critical. And perhaps trying to put oneself into the shoes of the judge and thinking about how those very important health issues would play at court would have been an important way to think about this claim. My suspicion is that the judge found the claimant to be a sympathetic witness and was concerned about the health issues that she faced. Last point, there was an interesting and unusual discussion about costs, and in particular the CFA uplift. I noted in a previous slide that the judge had provided in the award for a sum for the CFA uplift. And it's been suggested that this is now binding authority for the proposition, which is often argued and was occasionally successful, that in certain circumstances it may be appropriate for the court to take into account the CFA uplift or cost liability generally in considering an award. Certainly that is going to be a stronger argument, I think, than it had been as a result of this case. It's High Court authority to that effect, despite there being relatively recent cases in which such a claim had been dismissed or not granted. So that is an interesting further point to note in relation to the case. Now, that was a very quick run through of that case. Thank you very much for your attention and for joining us today. I'm now going to unscreen share, if that's the right way to describe it, and throw it open to the floor virtually. And if anyone has any questions, we'd be delighted to field them. Thank you.
Thanks, Charlie. We don't currently have any questions, although I'm sure some are on their way. So whilst we wait, a question for both of you really, and it's more of an anecdotal thing really. I hear what you say about Eilert and Mitson, about possibly making it harder for adult child claimants. My experience is not necessarily the law itself, but the publicity that that case garnered has actually seen an increase in speculative adult child claimant cases. Is that an experience that you two share as well?
Well, I think in truth, my experience is that the number of cases that come across my desk hasn't changed, and I don't sense that there's been an increase in the quantity of them. I do sense, and perhaps it's for the reasons that you've already said, that the solicitors who initially field those cases and are instructed on them are wary. And they're wary because of Eilert and Mitson, and they're particularly wary about the quantum element of the claims. I don't know, Annie, if your experience is any different, but yeah, that's how I see it.
Thanks, John.
Yeah, I don't think that I've noticed any particular increase in the number of claims or any decrease in their merit. But I think Eilert and Mitson certainly makes it, if nothing else, very, very difficult to quantify such claims, particularly in light of Lady Hale's judgment, where I think she says, yes, the claimant could have got nothing. She could have got what was awarded, or she could have got a lot more, and all of those would have been fine. So I think it does raise, real issues. While proclaiming to provide some kind of clarity, I'm not sure that it provided very much.
No, whilst also raising attention, I suppose, to the broader public as well.
Yeah.
Thank you. We don't currently have any questions. I wonder if everyone's keen to get off for their Easter break. So we'll give it another couple of seconds, and then I suspect we can probably look to wrap things up if that's the case. Oh, I spoke to your screen. Question directed to me. So it's usual in disputes over disposal to find that one side has paid for the funeral and maintains a claim to be entitled. Presumably this doesn't make a difference. No, my understanding is that it doesn't. I mean, if you engage the services of a funeral director, as I understand it, the contract is then between you and the funeral director directly, and then you then seek to claim that back from the estate. But I don't think paying for the funeral itself gives you any greater right over those I described in my talk, unfortunately. I hope that answers the question. Yes, I can let you have the authorities, no problem at all. Okay. Okay, unless anyone has any further questions, I think we can probably say thank you very much to everybody for attending. I hope it's been informative. It certainly has been for me. And yes, it just leaves me to wish you all a happy Easter and hopefully see you all soon. And thanks very much to my fellow speakers.
Thanks, Matt. Thanks, everyone.
Thank you.
Thank you. Cheers. Bye-bye.